Na mtazamaji, karibu tena, unatazama taarifa za leo mashinani, na basi nitakurejesha katika mahakama ya Kahawa ambapo mtazamaji, wakuu wa gereza la Kamiti wamefikishwa huko baada ya kukamatwa hapo jana kutokana na kutoweka kwa wafungwa watatu wa ugaidi mapema wiki hii. Basi moja kwa moja nitakupeleka huko.
We have not made that application. We are only notifying the court that the court has no jurisdiction. If the court agrees with us that it has no jurisdiction, these things die and they are moot. The state will look for a court that has jurisdiction. So we have not made an application that you transfer this matter to any court. You know, the state is saying, what prejudice does the first respondent likely or is going to face? The greatest, the mother of all prejudices. 30 days. The application to detain him. 30 days. If that is not prejudice, then the state as normal, and the first respondent, having been a prison officer, never knew that prisoners are prejudiced. He's not learning it. Lack of liberty for 30 days is no joke. And that is why we are determined to fight for his rights. There's massive prejudice. The notion being created here is that these people are being investigated for terrorism. Lock them in for 30 days. The state has been in a media frenzy saying that these people released terror suspects. These people, if at all they are convicted, released prisoners. They will, my first accused person, if convicted, the maximum he'll get is 7 years. Whether it is about a child who escaped from prison, whether it's a terrorist who escaped from prison, whether it's a defiler who escaped from prison, there is no sentence different than what they face under Section 124 of the Penal Code. Therefore, there is no complexity over this matter. It is a simple matter. A prisoner escaped. Are they liable for that escape? They will defend themselves. So bringing the angle of complexity is developing a nexus between terrorism and the first respondent, which is not, you know, is only the prejudice. They raised a very serious issue about prejudice. But I'm saying the argument and the aura about terrorism is to justify these people to be detained for more than 30 days. And that is why we are saying this court, this forum, it is clothed with the air of terrorism. A sitting trial magistrate's mind is focused on terrorism.
Your Honor, at this point I'm going to object. These are not the issues that came up in the initial application, in the initial PO, Your Honor. And I don't think we'll have an opportunity to respond to the issues that Mr. Omari is raising at this point. Your Honor, we ask you to intervene and ask that Mr. Omari sticks to the points in issue and not to deviate, Your Honor.
Lastly, I'm only responding to prejudice. We never raised it anywhere. It is the state that raised it. Lastly, the state raised the question of equality of the law. Equality of the law demands that they get justice before a court of competent jurisdiction. You know, my good advocate here, the DPP must be happy with that, raises Section 30 of the Prevention from Terrorism Act. It is nowhere in that application. The state is now expanding the scope of investigation. That affidavit is owned by a competent state officer, led by a senior assistant director of public prosecution. This is a simple question, as they have put it, aiding a prisoner to escape. That is a matter before an ordinary criminal court. And may you get favor on that application that we have, on that response that I've done.
Your Honor, let me try to be as brief as possible, and but let me also be as accurate as can be. Your Honor, you've been told this is a magistrate court. Fine. You're also being told that this court falls under the jurisdiction of Kiambu. Fine. We are not saying no. But if you look at that Gazette notice that has been brought by the state, does it say anything else apart from this matter falling under the supervisory jurisdiction of Kiambu High Court? That's the only thing that Gazette notice says, and nothing more. We cannot import anything else, as the attempt has been made by the prosecution. When you hear that there is a court that is dealing with criminal cases, when you hear that there is a court that deals with children matters, then we come to the anti-corruption court. These jurisdictions are specified, and therefore these magistrates are put in those particular courts. So their duties and their jurisdiction are well defined from the word go. Let us not try to bring any other definition by putting color into it. The law is strict about it. So if it is said that this is a terrorism court, this is which one that handles those matters, that is it. Do we have any other? When we are saying that this is a special court for that particular purpose, you can see where it is even situated, and you can see why it is put in such a situation. But then again, what does counsel say? That this is a matter that the court that deals with terrorism cases and other matters of high risk. So what is high risk then? That is what we'll have to come to. Is this a matter of aiding a prisoner, a high risk matter? Let us not define it by the kind of persons who escaped, because if it was a child who escaped, or a robber who escaped, or a rapist who escaped, or any other person who escaped, does that change the law? It does not change it in any way. It still remains an offense of aiding a prisoner to escape. Let us again not try to color this situation. So then the state comes and tells you, this being a magistrate court, they have sworn an affidavit and these people have been brought to court within 24 hours. We are not saying no. In fact, today for the first time, let's congratulate them. They have done something nice. They have brought them within 24 hours. But is that the issue? They have brought them within.
Na mtazamaji, tutaendelea kufuatilia yatakayojiri mahakamani na tutakujuza katika taarifa zetu za habari zitakazofuatia. Tukiendelea, shughuli za masomo katika kaunti ya Turkana zimetatizika. Hii ni kutokana na uhaba